Welcome everyone to the second of our Wilberforce 2022 Trust Conference webinars. First off, I'd like to thank you all very much for giving up your precious time to tune in to today's event. We really do appreciate your support. We're also delighted to welcome such a high number of you today, including those from many different jurisdictions, which is one advantage of this virtual format. We have an exciting program for you over the next 2 hours, consisting of 2 talks and 2 workshops, dealing with a number of highly topical areas relevant to trust litigation. We're keen that today should be interactive if possible, and we encourage you to use the Q&A button at the bottom of your screens to ask questions throughout the session. You can ask questions anonymously if you would prefer to do so. So let's crack on with our first talk, which is being delivered by Zoe Barton QC and Anna Littler, and which addresses the hot topic of trusts under attack in commercial litigation. Zoe, Anna, over to you.
Hi, good afternoon. Lovely to know that there are so many of you there, even if we can't see you all, unfortunately, this year, which is a great pity, but fingers crossed for next year. I think this might be the last we have to do like this. Right, well, myself and Anna are going to be looking at a couple of key decisions that those who act for trustees should be aware of in terms of trusts coming under attack. They are the decision in Ahmadova, which is a decision which concerns Section 423 of the Insolvency Act, and the decision in Securican, which is really a lesson about the use of receivers and the difficulty in doing too little too late in a piece of litigation. So they both have in common a theme of the fact that even though people might take steps to protect their assets with offshore, quite often offshore, not necessarily, but in this case, offshore trust structures, that's not necessarily always enough in order to make sure that those assets are not got at. And the English courts have become increasingly willing to flex their judicial muscle in respect of cases that have elements of wrongdoing in them in particular. So I'm going to hand over now to Anna to tell us a little bit about Ahmadova. I'm going to tell you a little bit about Section 423 claims in the broad sense of the word, actually. I'll do that first, perhaps, before handing over to her on the facts. Those of you who are regulars here may recall a couple of years ago I gave a talk on Section 423. It's a bit of a favourite of mine. We don't have a huge amount of time to go into all of the detail that we did last time, but you can always find the talk from a couple of years ago, the paper from that, to refresh you on some of the basics. But there are 4 essential requirements for relief. You need someone who's indebted to you and who has entered into a transaction. And the transaction idea is a pretty broadly construed idea. It can be a gift, for example, at one end, or it can be a more typical type of transaction. And that transaction is at an undervalue, and it's made with the purpose of putting assets beyond the reach of or prejudicing the interests of people who have a claim against you. The surprising thing for a lot of people is that despite the fact it's found in the Insolvency Act, it doesn't require any insolvent event. So the person who owes the money need not be a bankrupt, for example, and it probably helps to understand that it previously existed under the Law of Property Act 1925 before being reincarnated in the Insolvency Act. So it gives you a sense of maybe that it's part of a long history of measures that now find themselves in a slightly odd place. So don't let that put you off. The real test is that the statutory purpose under Section 423 is met, i.e. the purpose of putting assets beyond reach. You need to show that it was a purpose, that's the Hashmi decision and the Ahmadova decision as well, not the purpose, the whole purpose, only purpose, or a substantial purpose, just a purpose, just as the language of the statute suggests. And then once you get past that hurdle, the court has a very wide discretion in terms of the sorts of relief that it can give. Trustees need to be particularly wary that there's a possibility, unless they make it clear, or perhaps even if they do make it clear that they've passed on assets that they have received in breach of Section 423, that they have in fact passed those on. That makes it less likely that they'll be subject to a claim to give them back, for example. There is no formal change of position defence, but the sort of matters that come into play on a change of position defence might be relevant to the type of relief that will be fashioned. So that's worth understanding as well. But the breadth of 423 is its real appeal. It has extraterritorial effect, can be exercised notwithstanding that the assets or the respondents are outside of England. And it's also got some pretty lenient concepts of time. It's not fair to say that there's no limitation, but because there is, but time can start running depending on who the applicant is at different points in time. Much of the relief will have at least a 12-year, will have a 12-year period available. And that period can be even longer in circumstances where an office holder under the Insolvency Act eventually brings the claim. But I'm going to turn over now to Anna, who's going to tell us about the facts of Ahmadova and where the law has progressed since we last addressed this issue.
Thanks, Zoe. Yes, so the Ahmadova case has generated a lot of interest in divorce and fraud circles, but it's also really interesting from a trust angle, important for trust practitioners, because it highlights the risks that Section 423 can pose to trusts. And I'm just going to take this in three fairly short parts. First, I'm going to give a brief outline of the headline facts, then deal with the way in which the judge dealt with some of the defences raised by the trusts in that case to the Section 423 claim. And then at the end, Zoe and I will just spend a little bit of time on some points that might be interesting from a trust practitioner point of view and the implications of the case for trusts. So starting with the facts, in April 2021, judgment was given in the latest instalment of the Ahmadova litigation. It's been widely publicised due to the large sums involved and also the dramatic feuding family dynamic. And by way of brief background, at the end of 2016, the wife, Tatiana Ahmadova, was awarded just over £450 million in financial relief from her husband, Farhad Ahmadov. Both before and after the award, the husband divested himself of all of his assets, and needless to say, he didn't then satisfy the financial relief granted to his wife. In fact, the April 2021 decision, the judge said that the wife had been the victim of a series of schemes designed to put every penny of the husband's wealth beyond her reach. And the couple's son, Timur, who was unfortunately found to have been actively involved in his father's schemes, acknowledged in his oral evidence that his father would rather have seen the money burnt than for a penny of it to have been received by the wife. In relation to the claim against the trusts in the April decision, the husband's nominee had held approximately £650 million in cash in a Swiss bank account. This was then moved to a new Liechtenstein bank account in the name of the nominee. And from there, the assets were transferred into Liechtenstein Trust and then into further Liechtenstein trusts, the trustees of which were two Liechtenstein Anstalts, managed by a Liechtenstein firm who advertised its services as providing asset protection. So the wife brought a claim under Section 423 of the Insolvency Act and also Section 37 of the Matrimonial Causes Act to obtain money payment from the Liechtenstein trusts. We're just going to have a look at Section 423, not Section 37 of the Matrimonial Causes Act. So Zoe has set out some of the key principles of a Section 423 claim, and the judge summarised those principles and then dealt with the specific arguments raised by the respondents. And I'm not going to address them all here, but a few stand out as raising novel points or being of particular relevance in the trust context. And I'm just going to pick out three of the defences which were raised by the trustees in the case. First, it was argued that there was insufficient connection with the jurisdiction because the transfers all took place abroad and the recipients were foreign entities with no connection to England. This was rejected by the judge on the basis that there was a sufficient connection with England because the purpose of the transfers had been to evade a claim made in England by the wife who was resident in England. And it was noted that the same finding had been made in an earlier instalment of the Ahmadova litigation. The second argument raised by the trustees was that they argued that it would be oppressive or unreasonable to order them to make money payment to the wife because they were prohibited from transferring assets under Liechtenstein law, and compliance with any such order would give rise to a real risk of criminal prosecution of them in Liechtenstein. was also rejected by the judge, not only on the basis that she wasn't entirely convinced that it was supported by expert evidence, but also that the trustees hadn't identified any case in which inability to pay under a defendant's home jurisdictions prevented a money judgment being given in England. And she found that the question of how and where the wife's judgment could be enforced was a separate issue that would arise at a later stage. The third argument raised by the trustees was that an order to make payment to the wife would have exorbitant extraterritorial effect because it would relate to Liechtenstein entities in respect of assets located in Liechtenstein and in circumstances where such an order couldn't be enforced in Liechtenstein. The trustees also ran, but ultimately abandoned the argument that an order would be futile because it couldn't be enforced in Liechtenstein. So again, the judge gave these arguments short shrift. She drew a distinction between adjudication of liability and enforcement and found that the giving of a money judgment itself had no improper extraterritorial effect. On futility, it was found that the court would not refuse to decide matters before it simply because additional steps might need to be taken to enforce. And in this particular case, the judge found that a judgment would be of real benefit to the wife. And what's particularly notable is that she mentioned the possibility of the wife seeking an anti-suit injunction against the trustees, should they seek to take any steps in Liechtenstein to prevent enforcement of the judgment there by way of the wife bringing summary proceedings. And the breach of that injunction could result in committal proceedings being brought against the trustees in England. So just looking at the way that the judge batted off the defences raised by the trustees, the decision serves to re-emphasise the breadth and flexibility of the Section 423 claim and associated remedies, and the willingness of the English court to use it to assist a claimant who, in their quest to reach assets which a judgment debtor has attempted to put beyond their reach, including by way of use of offshore trust structures in jurisdictions where enforcement is more difficult. So now moving on to the third part of the talk, which is that there are some particular points of note in relation to trusts arising from the Ahmadova decision and in relation to the use of 423 more generally. And the first point I wanted to mention was that in comparison to other ways of attacking assets held in trust, such as alleging sham or illusory trust, or appointing a receiver over a power held by the settlor, Section 423 may present an easier route to a claimant and a much lower bar. First, there's no need to show any complicity on the part of the trustee, as is the case with sham. Second, there's no need to show that the trust provisions themselves point against proper divestment of the property by the settlor, as is the case with illusory trusts. Third, there's no need to show an enforceable right of the settler to obtain the property, which would be needed to appoint a receiver. All that's being examined in the trust context when it comes to 423 really is whether the statutory purpose exists when the settler divested himself of the assets into trust, because the other elements of Section 423, being a transaction at an undervalue by a debtor, will almost always be satisfied in the trust context.
I think on that point about statutory purpose, that's quite tricky, I think, for trustees in those situations, isn't it? Because we've got the nature of the trustee is that they don't necessarily know what's going on in the settlor's mind. Now, it will depend on the exact facts and how friendly the settlor is with certain trustees and so on and so forth. But it's far from a foregone conclusion that the trustees will know. And they may, even if they've been told something, only have a very partial view because 423 bites on transactions which, as we mentioned earlier, have got multiple purposes. It only needs to be a purpose to put your assets beyond reach. So that's tricky. And it's made trickier still by the fact that you don't have a close temporal connection between that transaction and 423 being alleged. So someone can go around effectively asset proofing, for want of a better way of putting it, quite a long time in advance and be found to have done just that in a way that's liable to redress under 423, but wouldn't have been apparent to the trustees at the time. So that potential future liability not being on their radar will make it uncomfortable for trustees when they realise that, in fact, in the meantime, they've distributed certain monies, for example, potentially.
Well, exactly. And I think these claims present problems to trustees in circumstances where they've distributed or otherwise no longer hold the assets in question. Because, as you mentioned earlier, Zoe, there is no change of position defence per se, trustees who may ordinarily be well advised to stay well out of active engagement with the proceedings may in fact need to step in to defend themselves if a transaction in which they're involved falls foul of section 423, so that they themselves are not required to pay over sums which they no longer hold. The trustee's state of mind will be a factor in determining what discretionary relief is granted against them, if any, under section 45. And so they may need to involve themselves in proceedings to a greater degree to attempt to demonstrate their ignorance of the statutory purpose, to protect their own personal position in avoiding a money judgment being made against them in circumstances where, if they don't engage, the claimant may seek to make inferences against them and their state of knowledge and the statutory purpose. I think the final point that I wanted to make on this was that, notwithstanding the protections offered to trusts in certain foreign or offshore jurisdictions against the enforcement of English judgments, the English court has shown itself in Ahmadova to be relatively unfazed by this and to be prepared to make the order against the foreign trustee regardless. So whatever may happen with the ultimate enforceability of the judgment, it may be of concern to trustees or their directors that they have an unsatisfied English judgment against them. And as I mentioned just before, in Ahmadova, the judge mentioning the possibility of the claimant seeking an anti-suit injunction enforceable by way of committal could be a very serious threat and highly undesirable to professionals working in trust administration, regardless of the level of connection they may have with England in terms of habitual visits for personal or professional reasons or otherwise.
Yeah, no, it's obviously very difficult for them because they're pinned into a corner essentially, aren't they? And that's obviously very effective, or was in that case at least a very effective way in compelling their engagement in proceedings here. I'm going to talk a little bit now about Securican, which went to the Court of Appeal and just over a year ago, about 15 months ago. As I said at the beginning, it's a tale that demonstrates the power of the appointment of a receiver by a claimant, which is one of the alternative remedies that Anna was mentioning in comparison to 423s. And it tells you a little bit about what happens when you don't get your act together in time, amongst other things, the importance of battle planning. Whilst it only went to the Court of Appeal relatively recently, it started its journey in the summer of 2012. So it took over 8 years from beginning to end in English proceedings alone. I'm going to deal with the first 5 years or so, which is sort of the claimants getting their way. And then Anna's going to deal with what happened when the defendants decided they wanted to do something eventually. And then we'll have some conclusions about that. So for those of you who aren't familiar with it, this was one of the many Russian bank-related claims. This was VTB, a bank claiming against a Mr. Securican. Mr. Securican had loaned, he was the founder and chairman of a business called Siberian Agricultural Holdings, or SAHO as it's generally abbreviated to. And they had lots of loans, $30 million or so, which they stopped repaying in about 2010. And the bank wasn't best pleased with that. The bank, in addition to thinking that he was the founder and chairman, had him down as a guarantor of these loans, and they had recorded in their own internal documentation that he was the beneficial owner of SAHO. So they went ahead and in 2012, they commenced proceedings in Russia and they enforced their guarantee. So far, so unsurprising. They did that at the same time as having already become aware that he had some interesting offshore structures and owned some assets in particular in Italy, where he owned a number of relatively expensive properties. And we all like a property because it's nice and tangible, and you can get your hands on it and sell it. So similarly timed to commencing their proceedings in Russia, they obtained a freezing injunction in this jurisdiction against Mr. Securican and any assets that he had a power to dispose of directly or indirectly. And they also got Chabra injunctions against some English LLPs. Now, these English LLPs, I'll come on and explain a little bit more about later, but they were parties to whom that VTB said that their assets were, as you'd need to do for a non-cause of action defendant injunction, were available to Mr. Securican. So they got associated disclosure orders against them as well. And all of that relief was granted under Section 25 in support of the foreign proceedings in Russia. Then VTB obtained summary judgment in Russia on the basis of its claims, or at least on some of them. And turning back now to the English LLPs and who they were, there were two of those. One was called Pikeville Investments and the other was called Perchwell Holdings. I don't know if the fish thing in Pike and Perch was on purpose or not. But Pikeville were the owners of the 18 million odd euro properties, and Perchwell was a Cypriot, held some assets in Cypriot companies, which in turn held some of the Saho companies. The people at the sort of centre of the web were two Swiss individuals called Meyer and Lurch, and a company associated with them called Crown Capital Holdings, a Hong Kong company. And essentially, VTB's case was that Securican was the ultimate beneficial owner of these LLPs. Now, upon disclosure, it turned out that in fact the membership interest in those two companies was held as follows, that there was a Liechtenstein foundation called Beringer, of which Securican was a discretionary beneficiary, but it was controlled by a board of directors. And the membership interest in Perchwell was held, again by the Swiss chaps, by the Beringer Foundation, once again, and also the Nevis trust called Olympic, again, of which Mr. Securican was a mere discretionary beneficiary. And it was controlled by some trustees who, surprise, surprise, are effectively the same Swiss gentlemen, once again. Now, in order to get to the bottom of that position, there was further disclosure ordered by the court. And VTB were quite clear in that what they wanted to do was to get this disclosure with a view to appointing a receiver by way of equitable execution over his interest in the LLPs, so that they could indirectly attach to the assets that they held, i.e. these Italian properties. And the point there is that if Securican had powers of, say, revocation or control over the trust or foundation, they could well be regarded as assets on which an injunction would bite. And they would be able to be the subject of the appointment of a receiver. And that had been established in the Tazarov Merrill Lynch decision in the Privy Council, which had affirmed the Court of Appeal decision a couple of years earlier, which was a decision concerning such an appointment over a settlor's power of revocation in two Cayman discretionary trusts. And it was held there that such a power was tantamount to ownership of the assets in the trust because they could simply be taken out. So Mrs. Justice Gloucester, as she then was, heard the application in this case, and she granted further disclosure orders, having been satisfied that that analysis was correct. And the reasoning there as to the existence of a trust in light of the extensive powers that could be reserved through the Liechtenstein Foundation's ability to have something called a mandatory in place was sufficient to swing her reasoning in that case. So a mandatory it can be an oral agreement, a mandate agreement, under which a person who is unconnected with effectively the board of directors can nonetheless direct the steps that they must take. So it provides a fairly obvious way around the internal written documentation as to the exercise of power and control under those underlying assets. Skip forward a couple of years, and Mr. Securican, who was also ordered to be examined, I think, on his asset disclosure, had failed to turn up and he'd been found guilty of contempt. For those of you who like sort of Russian top trumps on these things, he was sentenced to 16 months imprisonment in absentia, unlike Mr. Pugachev, who got, I think, a 22-month sentence. And in the meantime, VTB did, in fact, go ahead and appoint receivers over his interest in Pikeville in 2015. Now, the relevant date there was July 2015 that they'd done that. And they did that on notice. They had been required to serve not only the LLPs and Mr. Securican, but the various designated members, the Swiss gentleman, Crown Capital Holdings, the Hong Kong company, the Beringer Foundation, all of them were served. Now, despite that, none of them chose to submit to the jurisdiction of the English court, so they didn't engage in any substantive way with the merits of the application, and the relief that had been granted was sought basically on the basis of the expert evidence about how Liechtenstein foundations can operate. In due course, then Mr. Securican becomes bankrupt in Russia. There's a lot of back and forward up to their Supreme Court effectively as to whether or not that's right, and eventually the matter is settled. At that point, it seems that there was a sense of realization that there was an inevitable sale of these properties going to occur and the assets had been lost. And it was at that point, and that was, I think, because the receivers had caused Pikeville to enter into administration, that there was a realization and some activity. So Anna, can you tell us a little bit about what happened and when it happened, more importantly?
Yeah, so in 2017, belated activity was triggered, and Beringer irrevocably excluded Securican from the class of beneficiaries of the foundation, and Accreda did the same in respect of the Olympic Trust, apparently upon learning of the bankruptcy. In July 2018, the foundation issued an application to discharge the appointment of the receivers. And the principal ground which they relied on was a change in circumstance, namely that because Securican was no longer a beneficiary, he no longer had a direct or indirect beneficial interest in the assets of Pikeville. That argument was rejected as a clear abuse of process, as the purported change of circumstances was wholly within the parties' control. The court determined that the true purpose of the foundation's belated activity was to secure a discharge of the receivership. Among other reasons was the fact that Securican has been declared bankrupt more than a year before the exclusions, which suggested that his exclusion from the class of beneficiaries was merely a device designed to disguise his ownership and control of the assets and to frustrate VTB's enforcement efforts. The Court of Appeal rejected the foundation's appeal as ignoring the interrelationship between the mandate and the status of a discretionary beneficiary, because Securican was still able to procure the distributions of assets to himself. It was that which gave rise to an equitable interest in them, because even after his exclusion, he was still entitled to, under the mandate, to call for distributions to other beneficiaries, so that he could route assets via a nominee, even if he couldn't call for distributions directly to himself. So I think the foundation and the trust belatedly realised that there had perhaps been grounds on the substantive merits for disputing the relief sought by VTB in respect of the appointments of receivers further back in the chain. The court's jurisdiction won't be exercised unless a claimant can show that there's some hindrance or difficulty in using the normal processes of execution. And in the Securican case, it was obvious from the earliest reported hearings that VTB intended to seek enforcement by means of appointing a receiver. In those circumstances, the decision of the foundation not to submit to the jurisdiction and to delay taking any steps to distance itself from Securican ultimately precluded it from running arguments which, had it perhaps engaged before, may well have succeeded.
Yeah. Well, thanks for that, Anna. So yeah, it's a lesson basically in making sure you judge your non-engagement well, and in that case, it's a good example of where that wasn't done. We've got a written paper that accompanies this, you'll be glad to hear, and we deal in there also with the broad idea decision. I appreciate I'm probably running short on time, but just in a couple of sentences, the important thing about the broad idea decision is that it reinstates the black swan jurisdiction effectively. Obviously, in the BVI, they'd already introduced legislation, so it wasn't particularly relevant for that in itself. But what's interesting is the way in which the Privy Council articulated the test for an injunction, and where it said the boundaries for what was required for grant of an injunction were. And Lord Legate's speech is particularly interesting in that respect for those of you who want to have a look at it. In particular, it's pretty free and easy, and gives another, for those representing perhaps trustees in offshore jurisdictions to which this decision will apply, it's another potential difficulty for them to have to deal with claimants having easier access to attacking those trusts. A bit of a green light for the Chabra jurisdiction as well. And we'll probably see that trickle down in the various offshore jurisdictions where the Privy Council's decision is likely to be followed. Andrew, I see you've appeared.
Thank you very much, Zoe and Anna, for that very informative and also practical talk. I do think these cases go to show that when it comes to enforcement, English courts are open to fairly imaginative and sometimes novel approaches to ensure that effective relief is granted. Anyway, moving on quickly, given the time, we now move from commercial disputes and trusts to divorce and trusts. And this will be a workshop dealing with nuptial settlements and enforcement of divorce awards. And the workshop is being led by Tiffany and Lemuel. Hello, Lemuel. Hello, Tiffany.
Hi, Andrew.
Hi, Andrew. Hi, everybody. Yes, thanks very much. So we've got half an hour as opposed to the usual 1 hour to be dealing with our workshop today. We're not going to have any breakout rooms for discussions and that sort of thing. Lemuel and I are going to run through what's a fairly standard, straightforward question, which you will have had this morning, or I think you can access in the chat bar. Hayley's going to put it in the chat bar if you haven't got it in front of you. And we've set out at the end of that short paper a number of points to think about as we go through together, and there are some case names there as well to which we'll be referring. Now, one idea behind our workshop was to focus on nuptial settlements, and optimistically we thought we'd be able to bring you the latest word on when a settlement is a nuptial settlement, because a member of Chambers, a mystery member of Chambers, was expecting to have judgment handed down in an interesting case that might tackle some of these issues. Now, sadly, that hasn't come to pass, but we will, of course, still give an overview of nuptial settlements. We'll also be addressing what we can say is the latest word on judicious encouragement, and we'll be touching on some interesting enforcement and other practical and procedural points along the way. And Ahmadova will feature as well, so you'll remember what you've just heard about that case as we go through. So over to Lemuel, who's going to run through the problem question and just sort of summarise it for us. Thanks, Lemuel.
Yes, thanks, Tiffany. And I can see those of you who do want to have a look at the problem question, I can see that Hayley's usefully put that into the chat now. So if you follow that link, you'll get the problem question in front of you. Essentially, as Tiffany said, it's fairly standard. We've got Mr. and Mrs. Meff, who've been married for 20 years. They've got 3 children. In January 2021, they decide to separate and divorce proceedings commence shortly after. On Mr. Meff's side, there's a dynastic settlement called the X Trust, which is established in the BVI and is governed by BVI law, managed by BVI trustees, worth $60 million. The beneficiaries are Mr. Meff, his siblings and their issue. Spouses are included, but former spouses aren't. The X Trust itself owns its actual assets through a series of other BVI companies, and some of the ultimate assets which we're concerned about in this problem question include a London property which has been occupied by Mr. and Mrs. Meff and their children for the last 10 years, and also a Dorset property which Mr. Meff has had use of since before the couple became involved. Also, during the marriage, Mr. Meff has established various offshore structures under one BVI trust called the Y Trust, where the trustee is the same as that for the X Trust. This is worth 15 million and pays Mr. Meff a substantial income. In the divorce proceedings, Mrs. Meff is seeking to say that the X Trust and the Y Trust are both nuptial settlements, and she's seeking their variation. And obviously, Mr. Meff is saying the contrary, and that the trust shouldn't be varied, and in particular that the X Trust only provides him with fairly limited means.
Yeah, great. So the overall question is how is the court going to approach these 2 trusts, the X Trust and the Y Trust, and what's going to be done about the fact that Mr. Meff and to an extent Mrs. Meff have been afforded the use of these 2 properties in England. And so, as I'm sure most people will appreciate, there are 2 main ways the trusts and the use of these properties can be considered and brought in by the courts in matrimonial proceedings. You've got nuptial settlements, which are capable of variation under section 24(1)(c) of the Matrimonial Causes Act. And there's also the ability for the court to bring in as a resource trust assets. They can be brought in as a resource available to the parties under section 25(2)(a), and we've set out extracts from the Matrimonial Causes Act in the handout. So to begin at the beginning, starting with consideration of nuptial settlements, the first question we've got to tackle is, what is a settlement? And do we have more than one of those in our scenario? So we note at the outset that settlement is widely construed. One trust can give rise to several different settlements, and a settlement doesn't have to be a trust.
Yes, precisely. So settlement has a wide meaning in the case law that essentially encompasses anything which is continuing provision. So that can include an outright interest in a property, even where that property is itself held by a company. So that was a position in DR and JR from 2013. And in fact, it was held further there that the shares in the family company that owns the property could also be a settlement. So fundamentally, it's a factual question for the trial judge as to what is contained in the settlement, which is meant to be nuptial. So that can be the entirety of the trust, if there's considered to be a significant enough degree of continuing provision, or it might just be the specific continuing provision which is made by a disbursement or disposition out of the trust, the wider trust.
Yeah, and so just sticking with the theme of companies, you've got the case of Ben Hashem and El Shaif from 2009, where the company had allowed the wife to live in a property which the company owned, and Mr. Justice Mumby held that the settlement for those purposes was merely a revocable license to occupy the property, and that could be terminated on giving the wife a reasonable period of notice, which was considered to be 6 months in the circumstances. So in that case, also, the judge noted that this power under section 24(1)(c) is potentially unlimited. But while the court ought to be very slow to deprive innocent third parties of their rights, you do find cases where there are invasions of third party rights, where that's necessary for fairness, although sometimes some other benefit is given to other beneficiaries where their rights are interfered with.
Yes, and indeed, as an example of that, in AB and CB from 2015, which was upheld on appeal, Mr. Justice Mostyn found that the whole of a settlement which had been established and provided a home for the husband and wife fell within 24(1)(c) and therefore could be varied. And he specifically discounted the possibility that the subject matter was the right to occupy the property. And in that case, it was principally because of a clause in the trust deed, which meant the trustees had a specific power to advance all the property to the husband during his lifetime. And so he thought that made it clear that the settlement as a whole was in fact continuing provision.
Yes, and just as an aside, that highlights the need for care in drafting powers of appointment in relation to discretionary trust, doesn't it? But there are quite a few trusts that will include a power to advance all or most of a fund to a certain beneficiary. And in that case that you were just describing, the A, B and CB case, it may have been the case that power was exercisable only for the benefit of the husband, which suggested that the settlement on the husband therefore included all of the property as a matter of fact. So here we've got four potential settlements, haven't we? The X trust, the Y trust, and settlements arising from the ability to use both the London property and the Dorset property. Now, as we'll come on to see, if there's a finding that the London and Dorset properties are comprised in settlements which are capable of variation, that of itself doesn't render the X and Y trusts themselves capable of being or able to be varied. So that's a point that's worth remembering. So let's think about the nuptial element of a settlement. How do we establish whether that is present?
So the classic guidance on what's meant by a nuptial settlement is from Lord Nichols in Brooks and Brooks. And that is, to quote, broadly stated, the disposition must be one which makes some form of continuing provision for both or either of the parties to the marriage, with or without provision for their children. And that's been echoed fairly recently in DR and JR again, with Mr. Justice Mostyn saying that the test could be any arrangement which makes some form of continuing provision for both or either of the parties to a marriage. Now, those definitions do need to be approached with some caution because they don't quite tell us what makes the settlement nuptial. If we apply those phrases literally, that could mean that any trust which gave continuing provision was automatically a nuptial settlement capable of variation, because it gave continuing provision to a party to the marriage.
Yes, exactly. And so there's not much to go on there, is there? And only slightly more acceptably, more recently, in the Joy and Joy Marancho case from 2015, Mr. Justice Singer said, in order for a nuptial settlement to arise, the settlement has to have been in contemplation of marriage and because of the marriage. So, but that, again, that doesn't take us that much further. Ultimately, you'll want to look at all the relevant circumstances and take an overall view of what the settlement provides. So you'll have the identity of the settlor. Is that a party to the marriage, or is it a close relative? Who are the beneficiaries? Is there a letter of wishes? You know, the usual. You'll want to look at all of the circumstances in trying to establish whether it's got a nuptial character. So what if the original provision of the settlement could not be said to have been nuptial? Is it possible for the settlement to become nuptial as a result of subsequent events?
So this is a very hotly debated topic, and as some of you will know, it's not yet been settled by the case law, unfortunately. So on one side of the fence, we have Sir Paul Coleridge in Lee, Quan and Bray in 2014, saying that a settlement which is non-nuptial at its creation could become nuptialized if there's been a flow of benefit to the parties during the marriage.
Yeah, and on the other side of the fence, we've got Mr. Justice Singer again in the Joy Marancho case, excuse me. So he thought that the propositions in Lee Quan, he said they weren't binding on him, although obviously entitled to respect, they were overturned and they didn't reflect the law as far as he was concerned. So he took the view that a settlement, if you're going to say it's susceptible to adjustment, it's got to have been nuptial at the time of inception. So it's got to have been in contemplation of the marriage at the time of inception. So you can't go back with your retrospectoscope and change the character of the settlement from non-nuptial to nuptial. So you've got that conflict in the authorities that you've always got to be aware of. It seems likely, to me at least, that the better view would be that a settlement couldn't become nuptialized, and probably unwise to rely just on that, given that there are other routes through to achieving an award for the spouse. But as I said at the beginning, do watch this space, because there may be some comment on that in this forthcoming case that our mystery member of Chambers is expecting to be handed down imminently. So let's draw all of that together just for a moment and think about the four possible settlements in our scenario. What about the ex-trust? Do we think that's sufficiently nuptial?
So I think the ex-trust is likely to not be a nuptial settlement. It's dynastic, it's established before there was ever an intention for the parties to marry, and just because the spouses are included within the beneficial class doesn't suddenly make it a nuptial settlement.
Yeah, okay, fair enough. And so the Y trust, that's a little bit more difficult, isn't it? Because it's been set up with wealth which was generated during the marriage. It provides a continuing benefit for Mr. Meth as a party to the marriage. I suppose the main question is, was it made because of the marriage? It doesn't appear to give Mrs. Meth any potential entitlements to the money. She doesn't have any powers to apply any of the money. So you could say that it's not sufficiently nuptial, but on balance seems probably more likely that it would be regarded as a nuptial settlement. What about the Dorset property?
So the Dorset property is probably going to be reliant on whether you want to rely on nuptialization. So the original provision is likely not to have been nuptial. It was provided to Mr. Meth before the marriage and before there was even contemplation of the marriage taking place. It comes from the same dynastic structure as the ex-trust. And again, as we've discussed, although there's been use of the property within the marriage, A, that use has been fairly limited, and B, if you want to rely on that new use to establish that the settlement is now nuptialized, that's a pretty shaky route to take.
Yeah, okay. And finally, the London property. It seems likely that the provision of that house, it's a matrimonial home essentially. It's where the children grew up. Seems likely that ought to be a nuptial settlement. The question is that an interest that's been conferred on them as married partners? And probably the answer is yes. Okay, so let's move on. Let's think about how is the court going to approach variation of settlements with a foreign character. So assuming, for example, that the Y trust is found to be a nuptial settlement, how's the court going to deal with that, given it's a BVI trust? Well, the starting point is the court has power to vary settlements, even when they're settled abroad. That's the case of Charalambous from 2004. That's because the power of the court's based on the status of the parties who are before the court, rather than any election of the settlor or anything to do with the location of the trustees. However, as I'm sure most people attending today will realise, that doesn't mean that a variation would be enforceable in the territory where the trust is based, because most jurisdictions will have firewalls actively seeking to prevent enforcement of nuptial variations, and BVI is certainly a case in point, and BVI has just strengthened its firewall provisions by making amendments in respect of nuptial variations.
Yes, so indeed, as a general rule, the court is unlikely to make a variation order where that order is unlikely to be enforced. So in Quantum Bray, where the settlement was Mauritanian, the court Mauritian, apologies, I always get that one wrong. Where the settlement was Mauritian, and the court thought that on balance, the Mauritian court wouldn't enforce the order. The judge was unprepared to make a variation order. But obviously, it's not enough to simply rely on that. The court will investigate the circumstances in which enforcement may be possible and what an order may give a party, as was seen in Ahmadova and Ahmadova from last year, which Anna and Zoe talked about a little bit, but it's also relevant for our purposes. So although the trustees had said previously that the orders were unenforceable, the court noted that there had been some submission to the jurisdiction, and indeed that the court in Liechtenstein had noted that the English judgment, whilst it might be unenforceable, did have significant importance and couldn't be simply ignored by the trustees. On that basis, the court went on to make the orders sought and thought that enforcement could be tested at a later date if that was necessary. And indeed, the wife receiving those orders would have a practical benefit potentially for the enforcement of her award. As Anna mentioned, the anti-suit injunction, which the orders might allow her to obtain more easily, could well provide a real factual benefit. And obviously, where the assets of the trust are onshore, in England, the position can be a bit more different because the English court can exercise control over them. In terms of assets of the settlement, we should talk about where the assets of companies shared. So if one of the trust or settlements is found to be a nuptial settlement, in this case, obviously, we've got BVI trusts which own their assets through BVI companies, and where the property contained within the trust is technically those company shares. So Tiffany, enforcement of any variation is not likely to be possible in that scenario, is it?
Well, there's interesting workarounds which have been deployed by the family division in times past. So the courts have sometimes indicated a willingness to look through company structures when deciding what the settlement is for the purposes of Section 24. Famously in the DR and GR case, Mr. Justice Mostyn, and he thought that the entirety of the family company structure was itself a variable nuptial settlement. It's fair to say that there are severe doubts as to whether that approach would now be adopted, especially following Prest and Petrodel, which I'm sure everyone will be familiar with.
Yes, and indeed, with that tension, it's probably quite a dangerous strategy to adopt and may well lead to an appeal, even if the strategy is successful, given that that has not yet been tested, how much the two decisions can survive with each other. The safer view is probably that there should be a shaping of the order to take into account the assets of the trust as a resource, but not necessarily requiring the variation of the settlements. Equally, in this case, Mrs. Meff, for example, could say that because of other property which Mr. Meff has access to, he doesn't have a housing need, and therefore she should take more of the marital capital or other assets which are more easily traceable and enforceable against.
Yeah, okay, so there are other routes through, aren't there, potentially? Now let's think about procedural questions for a minute. Should the trustees be joined into these matrimonial proceedings? It's the age-old question that's been addressed in Wilberforce seminars in the past. Should we just have a think about that for a minute?
Yes, so I think the answer is generally that if a variation of the settlement's being sought, then it's best to join the trustees so they're bound. But if no variation is being sought because the trust is just being treated as a resource, then joinder is probably not desirable or necessary. Joinder is probably more important when thinking about enforcement and further enforcement proceedings that may take place in a foreign jurisdiction, where the trustees may be free to argue that the decision isn't binding on them. But if you don't have to join them, then it's probably best to leave them out, and maybe if you can and if you want them to, encourage participation by providing disclosure of documents or witness evidence, as they may be more likely to assist in those circumstances.
Yes, so not putting them under quite so much pressure to join in as a party. So trustees then have to think, well, should they be providing witness evidence or documents, and are they in danger of submitting to the jurisdiction if they do that? And again, we've covered this in Wilberforce seminars in the past. Really, the current view is providing that sort of evidence is unlikely to be submission. That's certainly what the courts have said. You as a trustee can provide information. It doesn't have to be in the form of a witness statement. If you are more comfortable providing it in the form of correspondence rather than official evidence, you could do that, although you run the risk of it being less persuasive if you're not offering yourself up for cross-examination. Just a small point to note in that regard is also, if you're acting for the trustees, you've got to be careful not to say something along the lines, well, the trustees will just abide by whatever order the English court makes, thinking that you're being good and taking a neutral stance. That may itself be taken as the trustees submitting to the jurisdiction.
So in the circumstances where we do have to have joinder, i.e. you really want a variation of a settlement, the procedure for joining parties is under the FPR, the court may direct that a person is added to proceedings if it's desirable to add the new party to resolve all matters in dispute, or if there's an issue involving the new party and an existing party which is connected to the matters in dispute and it's desirable for that issue to be resolved. Some guidance on this was given in DR and GR again by Mr. Justice Mostyn. He thought that there should be two limbs, that the applicant for joinder must show that there's an existing matter in dispute which requires joinder for resolution, or that there's a matter in dispute between a party and the new party which is connected and it's desirable to resolve all the issues together.
Yeah, so if you're seeking joinder in order for there to be better enforcement of an order in a foreign jurisdiction under either of those two limbs, you would do well to have evidence that joinder is actually going to make a difference, because just making that assertion or stating your belief to that effect may not be enough. But those are not considerations that have necessarily been followed in practice. I think it's right to say that in Ahmadova, joinder was given a pretty light touch. It doesn't seem, I think, in that case, that evidence of foreign law was given, but that you probably do well to think about giving evidence of foreign law.
Yes, and in terms of variation, and to the extent the checklist has to be specifically applied, you've also got the ruling in TM and AH from 2016 that in Mr. Justice Moore's view, if you're applying for the variation of a settlement, then Article 6 of the ECHR requires that trustees are joined before a variation can be made. So on that score, it may be quite simple to join trustees for variation, because if it's required under the ECHR, then clearly they're required to resolve the issues in dispute. Yeah,
exactly. And as a small point, again, just to wrap up on joinder, don't forget you've got minor beneficiaries here. So Stephanie and Bob ought to be represented unless the court orders otherwise under the FPR. Right, so let's move on from nuptial settlements and joinder and think about trusts as a resource under section 25. What are some of the relevant factors for the court to think about in determining whether assets should be treated as a resource?
So there's quite a range. So firstly, you want to think about the source of the trust assets. Are they dynamic, or are they flowing from the marriage? That follows on with the nature of the assets. Are they liquid or illiquid? Where are they located? Is there an intention to retain them over generations? Is there a sentimental attachment to them, which means they need to be retained? The history of past distributions to the spouse and whether they're capital or income in nature, the needs of other beneficiaries, and the likely attitude of trustees if they're faced with a request for a distribution to make provision for the other spouse.
Yeah, so all the things you would expect looking at matters in the round. One very important question that arises here is what's the role and function of the court in considering whether trust assets should be treated as a resource. How far can the court go at determining those factual issues and giving judgment that might impinge on the way the trust is run? And we're thinking here about judicious encouragement, that phrase, that term, which has been the subject of recent comment in the English court.
Yes, so the position is that a judge can't judiciously encourage trustees to provide funds to meet an award for a non-beneficiary spouse, but they are entitled to have regard to the fact that if one spouse is left without significant funds, it may well be that the trustees will step in to help the beneficiary spouse. And that's because the statute is clear that the family court is not limited to considering property held by a spouse, but it can consider their resources generally, which includes their interests under trusts.
Yes, exactly. So at that position, as you've just explained it, no judicious encouragement, thank you. That's endorsed most recently by Mr. Justice Mostyn in the case of Villiers and Villiers from 2021. So whilst there shouldn't be separate judicious encouragement, where the court makes a finding that support is likely to be given in the future, it's proper for an award to be made on the basis of that factual finding. Yes, and I think it's important to note that it's a finding of fact on the civil standard that financial assistance is likely. So it doesn't have to be an absolute certainty, which means the trustees do have a bit of a choice about how they want to play it. Yeah. Okay, but the trustee can still be in quite a difficult position, doesn't it? If it wants to provide evidence to the court, and I suppose they can say to the court, well, we'll take a constructive approach to any request for funds made as a result of your decision, court, but naturally we'll have to consider that request very carefully, taking into account all relevant circumstances, etc. Assuming it's a discretionary trust, they'll have to say, well, we're not able to fetter our discretion in advance of any request being made by giving an indication of how we're minded to exercise our discretion, because circumstances might change and the trustees will want to consult with other beneficiaries before making any decision. They might want to take advice from their legal advisors and property, finance and tax professionals and that sort of thing. Yeah, so to draw it all together in terms of how this applies to our problem question, in terms of the ex-trust, it's probably quite difficult to say that the settlement as a whole will be considered as a resource, although obviously the fact it's provided two properties to Mr. Meth will suggest that there is something there which he can draw on. Equally, those properties aren't being given on an absolute basis, so the court may well think that in the event Mr. Meth is left penniless, this trust is not going to be assisting with a nice juicy payout. So on that basis, it's probably unlikely to be considered a full resource, but the court could probably make a finding that the trust would be likely to provide Mr. Meth with accommodation other than on a capital basis. And on the facts in this question, I'd suggest that's probably an appropriate finding to make. Yeah, okay. And as regards the Y trusts, by contrast, it seems pretty likely that that would be seen as a resource, doesn't it? It pays regular income to Mr. Meth, has made capital distributions to him in the past. And of course, there's no need to find that that's a sham or to look behind the trust in any way for finding that a trust is a resource. All you need is finding a fact that support's likely to be given in the future. Yes, I'm conscious of the time, but I think we should probably just do a whistle-stop tour of some thoughts about enforcement of these orders. Yeah. So what could Mrs. Meth do to get her hands on the trust assets if Mr. Meth won't pay up the award made? Yeah, so if he doesn't look like he's voluntarily going to pay up, she could ask the court to consider ordering him to make a request of the trustees to pay him a particular capital sum to discharge his obligation to her. And she could ask that in default of making that request, then a third party or the court should itself make the request of the trustees on his behalf. There are some cases that you could rely on in support of that. A case of Blight and Brewster from 2012. That was a case about a pension arrangement. There's the case of TSMF and Merrill Lynch from 2012 as well. Both cases, well, the court was relying, in Blight and Brewster, it was relying on Section 37 of the Senior Courts Act and saying, well, a judgment debtor ought to sign a letter to be presented by the claimant's solicitors to delegate to them the power to make in his name an election to receive a payment from his pension. So you want to get your hands on the money in the pension. He's got the power to request a tax-free payment from the trustees. If he won't do that himself, then you can order him to do it or get a third party to do it on his behalf. Now, there are features of the present case in our scenario, which obviously distinguish it from Light and Brewster and the TSMF case, because in those cases, there's a power that the beneficiary has that could be regarded as it's a right tantamount to ownership of the underlying assets, essentially a power to revoke a trust or a power to elect to take a lump sum. So it doesn't really apply here, but you might in future have a case on particular facts that would make it easier to run that sort of argument, which might find favour with the court. So if the court did make an order of that kind, what do you think the trustees should do if they're faced with this request, either from Mr. Meff or from a third party?
Well, I think it probably depends on partly the request itself. So the trustees might say that they'll consider any voluntary request made by Mr. Meff or a third party on his behalf to be a valid request. But if the request has not been made by him voluntarily, but has been contrary to his wishes, which he's made crystal clear, then obviously that will be an important consideration for the trustees to take into account when deciding whether they accede to the request in whole or in part at all.
Yeah, exactly. And if the sum is substantial, then and if especially if the request is made against his wishes, then the trustees might want to seek the court's blessing for any decision that they make. They could ask for the blessing application to be heard by the same judge who made the order in the ancillary relief proceedings, and that would be cost effective and efficient. But they might think, well, it would be preferable for a blessing application to be made before a different judge in the Chancery Division who's not had any involvement in the ancillary relief proceedings, and so there can't be any suggestion or appearance of bias. Okay, well, that brings us to the end of our session. If anybody's got any questions or anything that arises out of that, do feel free to get in touch with me or with Lemuel. You've got the handout that had the, it's got the case names on it, but if anybody wants to ask any particular questions, then do, as I say, feel free to get in touch.
Thank you very much, Tiffany and Lemuel. I must say you managed to cover an extremely impressive amount of ground in a short space of time. I had just one quick comment. I've always been less than convinced about the appropriateness of the use of the term judicious encouragement. And I think Mr. Justice Mostyn's adoption in the Villiers case of what the Chief Justice of Hong Kong said about the term being unhelpful is to be welcomed. I think based on what you both said, that's your view too, but if it's not, do shout.
Yeah, yes, absolutely. It certainly clarifies the use of the phrase, isn't it? And sets out a bit more clearly that it's important that there should be findings of fact on the balance of probabilities, and you're not in any way exerting any pressure on the trustees. This is just an exercise that the court goes through on the evidence that it has. Yeah.
Yeah. Okay. Well, hopefully we've seen the back of that phrase. Okay, thank you. Right. Well, we're sticking to the family theme with our next talk being entitled Modern Family Trusts in a Time of Rapid Social Change. This talk is going to be given by Simon Atkinson and Joseph Stedman. So over to you both.
Thank you, Andrew, and good afternoon, everyone. Joe and I would certainly like to extend our welcome to everyone attending remotely today. As Andrew mentioned, the topic for Joe and me is modern family trusts in a time of rapid social change. And we chose this topic not just because we think it's important and interesting in its own right, but also because there have been some important recent decisions which have considered these issues. Now, as we all know, trusts can have a very, very long shelf life. Many of the trusts that we will come across in our professional lives will have been going for 30, 40, 50 plus years and still may have decades left to run. Yet when we think about the changes in the social and legal landscape which have taken place during the lifetime of those existing trusts and which could still occur during the rest of the lifetime of those trusts, they are tremendous changes. We think about the changes in social mores and legislation in even the last 20 to 30 years. It's less than 10 years since the passage of the Marriage Same-Sex Couples Act. And so when one thinks today of what a modern family is or could be, there are just a huge variety of possibilities, many of which were historically neither recognized in law or even by societal norms. Now, this evolution may give rise to potential uncertainties for those who are administering all the trusts. Terms such as spouse and child 30, 40, 50 years ago may have meant something very different to the testator or the settlor of that old trust from how a modern day settlor or testator might understand those terms. And it's that implication of that evolution which is really the focus of our talk today. Joe's going to focus first on what the common law's default conception of the family is and how that's been affected by legislative and case law developments over time. And then I'm going to consider a very recent decision of the English court in which I was instructed and which grappled with these very issues. It's hot off the press as of last Friday, so it will hopefully keep everyone up to date. And then after that, Joe and I will conclude with some practical tips. So over to you, Joe.
Good afternoon, everyone. I'm going to start by talking about the common law's default conception of the family, and that really only goes back maybe 30 or 40 years before the legislative interventions, which I'll talk about a little bit later, came in. And as a broad generalization, the common law world had, absent that legislative extension, a narrow default conception of the family. However, unlike in civil law and Quranic law countries, where there are often entrenched heirship regimes which impose limits on individuals' ability to depart from that default conception, in common law jurisdictions, as a rule, the default has not ever been very strongly enforced. And one way into this is to consider the rules of intestate succession. So where there's no valid will, as many of you will know, legislation intervenes to impose what might be thought of as the law's conception of the default form of family. Spouses and civil partners are given priority. Where there's a surviving spouse or civil partner and no children, then the spouse or civil partner takes the whole estate. And if there are children, then the surviving spouse or civil partner gets the deceased personal chattels, a fixed net sum of £250,000 and half of the residuary estate, with the rest being held for children and their remoter issue. Children are then the next category. So if there's no surviving spouse or civil partner, but there are surviving children, then they share the entire estate. So far, we're looking at a very nuclear conception of the family, and before the extensions of the meaning of spouse and child, a very limited sense of what those were. After spouses and children, if there are no spouses and children who survive, the next class of people who might inherit are parents, and then if they're all gone, it's whole siblings or their children, so nephews and nieces. Then if there are no whole siblings, half siblings or their children. So it's important to see that if you had a brother and a half brother, only the brother would receive the entire estate upon your death. And then after that, grandparents, and then whole uncles and aunts and their children, and then half uncles and aunts and their children. So again, discriminating between half cousins and whole cousins. And after that, the property vests in the crown. So there's, once you get to first cousins, if you no one alive up to and including first cousins, it goes to the crown. And that's different from other jurisdictions, including, for example, Russia, where the law recognizes 5 degrees of kinship. So that's something like your great grandparents' descendants all the way down. Who is missing from that default conception of the family? Well, first, there's no automatic provision for cohabitants or other unmarried partners. They don't get a look in. Second, there's no provision whatsoever for stepchildren. And third, there's no provision for the extended family, as I mentioned. What makes this less operative is that the common law's default conception of the family can almost be entirely overwritten if the deceased has made a valid will. Then it's up to the deceased to define who they think is their family, and indeed who else they want to benefit, such as friends and charities. And unlike in entrenched heirship jurisdictions, it can also exclude any of the categories of person who fall within the default. So you can disinherit one of your sons, for example, if you don't like them. That principle of broad testamentary freedom is constrained only by limited statutory intervention in some jurisdictions to protect particular classes of family member, especially spouses and dependents. And so, as many people will know, in England and Wales, we have the Inheritance Provision for Family and Dependents Act 1975. And there's a right for various categories of applicants to apply for reasonable financial provision. So that broadens out the class of people who the law considers might be within someone's family. So we have surviving spouses or civil partners, that's the same. Former spouses or civil partners, provided they haven't remarried or reformed a civil partnership with someone else. Cohabitants, so that this is the first time we see them in the frame legally, as long as they have lived in the same household for the past 2 years. Children, people treated as children of the family, so that then could extend to stepchildren or any other dependent. So that's a broader conception of the family, but that breadth is counterbalanced by the discretionary nature of the jurisdiction. Unlike in intestate succession, where there are fixed shares for fixed categories of people, the court just provides what it thinks is reasonable. What's the significance of this? Well, as different kinds of family become more common, especially blended families where there might be 2 sets of stepchildren, or even 2 sets of stepchildren plus children that both parties have had together, these sorts of claims are on the rise. In 2020, there were 192 cases brought by the High Court under the 75 Act, which was up 50% on the 128 cases heard in 2018. And it's tipped to increase because around half of UK parents are planning to treat their children unequally in their wills. There's similar legislation in many other common law jurisdictions, albeit with varying classes of potential applicants. That includes Scotland, New Zealand, Australia, but notable exceptions include most US states and the Cayman Islands. So there, testamentary freedom is almost entirely unconstrained. So that's the narrow common law conception of family. And what has happened over the last few decades is that the law, or rather the legislature, has responded to changes in society's conception of the family by making various extensions to the concept. And really it's in 2 main areas, children and spouses. So the first area in which there has been an extension is to do with children. And at common law, children is construed as meaning legitimate children, which is children who are conceived or born during the currency of their parents' valid marriage. And then there are some extra bits. So you can be legitimated if the law of your father's domicile says that you have been legitimated, or you can be legitimate by the law of your parents' domicile, shared domicile. The common law rule in favour of children meaning legitimate children could be displaced by showing either that it was apparent from the language used by the settlor or testator that the gift should be for a broader class, including illegitimate children, or if it was impossible from the surrounding circumstances for a legitimate child to benefit. So if you just didn't have any legitimate children, then the court would accept that you meant your illegitimate children when you said children. So the common law discriminated against illegitimate children, as well as adopted children whose status was a creation of statute and so wasn't recognised by the common law. Over the last few decades, though, there's been a series of statutory interventions, which means that children are now subject to various limitations, which I'll come on to, treated as including illegitimate children, legitimated children, children born of void or voidable marriages, adopted children, and children born through assisted conception or surrogacy arrangements. The big class that are missing from there is stepchildren. Spouses, likewise, the definition has been updated by statute to include marriage between same-sex couples. There has not been a blanket extension of the concept to include civil partners, though Simon's going to come on to a recent consideration of that. Nor does the definition of spouse automatically include cohabitants, also called common law spouses. And again, I think Simon's going to briefly mention something about that. Importantly, in all of these cases, statutory interventions are subject to important limitations. So they take effect subject to a contrary intention expressed in private law documents. So you can still choose to exclude your illegitimate children or the same-sex spouses of your children, or whatever you want to do, if that's what you want. The legislative interventions only take effect with prospective effect, so you have to look at when each trust was set up. And third, there's still various gaps. For example, a person who's undergone a ceremony abroad which doesn't qualify as a recognisable marriage in England and Wales. So there are still things which the court's going to have to think about. The other legislative extension is through human rights. And this doesn't only apply in the UK, but also, of course, across Europe, and as well in United Kingdom overseas territories. So the Bermuda, BVI, Cayman Islands, Gibraltar, Jersey, Guernsey, and the Isle of Man all have had the European Convention on Human Rights extended to them. And although those rights are only addressed towards state actors, they have impacted in the courts upon private rights, including through the interpretation of trusts. The case that Simon is going to talk about touches on those, although it's not an example of the court deciding that it should deciding a case on the basis of human rights. What's interesting about that is it's, in my view at least, a departure from the usual role of public policy in the law of trusts, which is normally limited to exceptional cases. And so that gives rise to considerable uncertainty and will probably mean trustees needing to run off to court and ask what to do more often. I want to mention three interesting cases which are less recent than Simon's, before Simon gets onto his very, very recent case. The first is from 1970. It's called Re-Remnant Settlement Trusts. And it's an example of the court approving a variation to a trust under the Variation of Trusts Act 1958, contrary to the prejudices of the testator, who had sought to exclude practicing Roman Catholics from benefits. The court recognised that it would not be in the interests of the members of the beneficial class to be required to choose between religious faith and taking benefits under the trust. And so it struck down the provision which discriminated against Roman Catholics. There is then Re-Y&Z Trust in Jersey in 2017, where the court approved variations, again, widening the beneficial class to include same-sex relationships, illegitimate and adopted children. There, it took into account the need to maintain family harmony as a benefit to the beneficial class, and also took into account contemporary public policy. The last case I wanted to talk about is PQ and RS, which was referred to in Simon's case. In that case, the trust had been created just before the law on illegitimacy changed, and there was one daughter who had been born just before her parents were married, and so was the illegitimate child. The court blessed as a proper exercise of the trustee's powers a decision to amend the beneficial provisions by broadening the class to include illegitimate descendants on the basis it was for the benefit of all of the beneficiaries, including even the legitimate children, because they might ultimately have illegitimate grandchildren in the future. Over to Simon.
Thank you, Joe. Well, as promised, there's a very recent update on this point, on some of the issues that we've raised, and that's the case of Goodrich and AB, 2022 EWHC 81 Chancery. It's a decision of Chief Master Schumann, and it was handed down last Friday, so I suspect that many of you may not have got around to looking at it just yet, unless you're super keen, keeping an eye on Bailey. Now, in this case, the court was asked to construe the objects clause of an employee benefit trust, which had been established in 1990. And the beneficiaries under that clause included spouses and children of employees. And the relevant questions for the court on this particular application was whether same-sex spouses and civil partners were included in those terms, given the age of the trust. Now, the factual background briefly was as follows. There were two trusts, the Walker Books Employee Trust, or the WBET, and the Walker Books Limited Employee Share Ownership Plan, the ESOP. And the trustees had entered into a conditional share purchase agreement for the sale of the shares they held on trust, and sought court approval for completion of that sale under public trustee and Cooper principles. Now, approval was given in February 2020 and the sale completed in May 2020. Now, the trustees wished to distribute the proceeds of sale, but before doing so, sought determination as to the scope of the beneficial class. Now, for the construction application, beneficiaries had obviously been appointed to act in a representative capacity to argue certain points in relation to the meaning of the beneficial classes, including one term retired, which also appeared in the objects clause. That's not relevant for today's talk, but several of the defendants who had been appointed to argue that point were either unable because of conflict or unwilling to argue for a narrow construction of the term spouses and children, which would exclude respectively same-sex couples and civil partners and stepchildren. And so the trustees, who I was instructed by, who were neutral, were tasked with advancing arguments in support of narrow constructions on each of these terms, so that the court would have the benefit of full argument. Now, on the question of spouses, which is where the judgment on this particular point sort of focuses, in 1990, at the time this trust was created, there was, of course, no such thing as civil partnerships recognised in English law, and persons of the same sex couldn't marry. Now, while the Civil Partnership Act in 2004 brought about a change in the law by permitting persons of the same sex to enter into a legal relationship which was identical to marriage in its legal incidence, now, the statutory regime doesn't purport to change the common law definition of spouse so as to include civil partners. You'll see in the Act there's a terminological distinction which runs right through it between, on the one hand, civil partnerships and on the other, spouses. And the Act also didn't purport to change the effect of existing private settlements. So that was sort of civil partners and law. Then we look at same-sex spouses. Now, as far as they're concerned, Section 11 of the Marriage Same-Sex Couples Act provides that in the law of England and Wales, marriage has the same effect in relation to same-sex couples as it has in relation to opposite-sex couples. That's sort of the big ticket to change in the law that the Act introduced. But that provision under Section 11(1) is limited by Section 11, subsection 4 and Schedule 4. And paragraph 1 of Schedule 4 concerns existing private legal instruments such as wills, deeds, and so forth. And that says that Section 11 doesn't alter the effect of any existing private legal instruments. And the explanatory notes to this provision state in no uncertain terms that the intended effect of these provisions are prospective only. It says at paragraph 111, this provision means that the introduction of marriage of same-sex couples will not affect the meaning of any marriage-related reference in documents such as wills, deeds, and documents governing charities drawn up prior to Section 11 coming into force. Well, that's exactly the deed that applied in this case. So the trustees sought directions from the court as to the proper construction of the term spouse in light of this legislation, but also in light of the Human Rights Act. A representative defendant was appointed to argue for a wider construction of the term spouses that included civil partners and same-sex spouses. And the principal arguments were twofold. First, it was said the term spouses in the deed should be widely construed so as to mean a legal relationship between two people which confers similar rights to those enjoyed under marriage. The second principal argument was that if that wasn't possible, the court should adopt a convention-compliant interpretation of spouse by reading down the CPA, the Civil Partnership Act, and the Same-Sex Marriage Act in a way which eliminated any distinctions. Now, the court agreed with the first argument in relation to the term spouse. Although there wasn't much by way of contemporaneous documentation which shed light on the settlers' objectively manifested intentions as to the meaning of the word spouse, the court relied on the commercial purposes of the trust in support of a wider interpretation. It said the settler wished to reward and incentivize employees, and he intended that the dependents of such employees should be able to benefit. And given that commercial purpose, it was open to construe spouse as including civil partners and same-sex spouses. The court said that employee trusts were a more flexible living and breathing long-term trust, a key feature of which was to reward officers or employees for past contributions, distinguished against private family trusts. Now, this suggests there might be a difference in interpretation and the effects of commercial trusts on the one hand, which the meaning and effects of which may shift as legislative and common law developments evolve, while other trusts, specifically private family trusts, might potentially ossify. It also seems to me that the court's approach suggests that wider constructions of family relationships may apply where the nature of the relationship amongst beneficiaries is immaterial to the commercial purposes of the trust. So that was the principle based on which the court decided the point. So it wasn't actually strictly necessary for the court to consider the human rights argument, but the court did nonetheless. And so far as civil partners was concerned, although the court accepted that a decision not to construe spouse so as to include civil partners was discriminatory and infringed convention rights, and while the court accepted that the Civil Partnership Act failed to cure that discrimination, the court concluded that it couldn't read down the Act compatibly with the ECHR, because by doing so, it would inevitably elide spouses and civil partners, which went beyond what a court could permissibly do. So far as the Same-Sex Couples Act was concerned, however, the court concluded that it could read down compatibly that act with the ECHR, the effect of which was broadly to leave undisturbed pre-Human Rights Act distributions to beneficiaries or other exercises of property rights, but otherwise to alter the effect of existing private legal instruments prospectively. Now, that might seem a surprising conclusion in light of the wording of the Act and the explanatory notes, but it is consistent with the general approach of the Chancery Division in recent years to try to construe private settlements, even old settlements, consistently with modern conceptions of family relationships and in a way which mitigates discriminatory effects. That's quite an important point, I think, in the judgment. That was spouses. So far as children were concerned, I can take this much more quickly. In essence, the court simply held that the term children excluded stepchildren. That's long been the position of common law. The term child does not include stepchild in the absence of an express provision to that effect or an extended meaning arising from the context. There was nothing to indicate such an extended meaning. And importantly, it was always open to the settlor expressly to include stepchildren at the time that the trust was created. And the human rights argument was not successful because the court rejected the argument that a distinction between stepchildren and children was discriminatory. It simply reflected the relational difference between the two. That's a whistle-stop tour through what I think is quite an important decision, and you can find it on Bailey. But we conclude now maybe with some quick practical consequences for trust practitioners. Joe, what do you think? What are some of the key practical consequences for trust practitioners and lawyers?
Well, let's start with settlers and those who are involved in the drafting of trusts now. The important thing, I think, is to be aware of the default rules of construction, both at common law and as now extended by legislation, and then to consider whether the settlor wants to broaden or narrow those key definitions, in particular spouse and child. Does the settlor want to make sure each of those has the widest possible meaning? Do they have reasons to want to limit that meaning? Secondly, I'd suggest taking particular care with provisions which seek to treat individuals differently based on protected personal characteristics such as gender. If you have particular beneficiaries you want to make different provision for, you're much better off referring to them by name than by reference to a characteristic like that. Third, I'd suggest considering including powers which will enable future trustees to respond to changing conceptions of the family. So think about powers of amendment and that sort of thing. And fourthly, explain the settlor's thinking in a letter of wishes. That came up in Simon's case, obviously, and that's particularly important if the settlor's thinking might be thought to go against prevailing social attitudes. So if you've got a conservative settlor who wants to keep things to, opposite sex marriage and legitimate children, then explain the reasons why, so that you don't have a court thinking that society's moved on and going against the settlor's wishes. Secondly, trustees. Simon, do you want to talk about trustees?
Yes, so from the trustees' perspective and those involved in administration, you might want to consider whether it would be appropriate to broaden key definitions, and if so, how you can do that. Can you do it through an exercise of power of amendment or addition or appointment? If those routes aren't available or are uncertain, can you apply to court for directions or a variation? A variation might not be available where you've got a large class of adult beneficiaries, such as was the case in my case, but directions you could go for. But in any event, make sure your decision-making isn't tainted by any preconceived determinations or discrimination or bias, including stereotypes about the characteristics of particular beneficiaries, because that will obviously potentially void or render your decisions in breach of trust.
And then finally, I think the third category, I suppose, is beneficiaries and those who are involved in litigation about their rights under trusts. And for them, it's important to be aware of the impact of human rights and the potential routes that that provides to challenge discriminatory trusts. And on the flip side, to consider whether there are life events which are about to happen which might affect entitlements under trust. So, for example, it might be that if there were a discriminatory trust discriminating between male and female beneficiaries, a transgender beneficiary might want to delay taking steps towards gender recognition until the interest is vested. That's an enormously important step and an enormous constraint on a person's freedom. But if there is sufficient kind of financial reason to do so, it may be that that's the only safe outcome. In all of this, it's important to balance adaptability with certainty, and to try and find a middle way through all of these difficult points. I don't know if there are any questions. I haven't seen any pop up.
In terms of notes, I think papers are going to be circulated in due course, I think. Is that right? So I see Andrew's just come back on the screen.
Yeah, thank you, Simon. Yes, the question's been asked about when and whether the notes of the talks will be made available. I've been told these should be circulated hopefully later this week. And those notes will also include notes from the talks given at the webinar last week. There was also a question, I think, on the chat, Joe, for you about the source of your statistic about half of UK parents planning on treating their children differently in their wills, where that comes from.
Yeah.
For the benefit of anyone who hasn't seen your written answer, can you just confirm where that's from?
Yeah, it's from a poll undertaken by an organisation called Census Wide, and it came out in September 2021. It was reported in the Financial Times, amongst other places. It just shows you, I think, how much this sort of thing is going to continue to be an important issue.
Yeah, well, thank you, Simon and Joe, very, very much for addressing a clearly a very relevant topic in the trust world. So that means we've now reached our final session, which is a workshop dealing with the exciting topic of investment powers and cyber currencies. Personally, I'm hoping at least to pick up some investment tips or to find out whether I've already missed the boat on cyber currency. This workshop is being taken by Lawrence, Stephen, Daniel and Ram. So over to the four of you.
Well, good afternoon. There are two differences in this workshop from our traditional Wilberforce method. The first you'll have already seen and realised we're remote, so it's curtailed what we like usually to be a lively, interactive style with plenty of heckling, and I certainly receive my fair share of that normally. Dan and Ram, who are on this session as well, will be picking up questions and trying to put the difficult questions to either me or Stephen. So please fire in your questions and we'll try and answer them in the course of the session. There's a second difference, which is perhaps more profound, and that's the level at which this session is aimed. Wilberforce usually tries to look at the margins of the law, pushing and developing it further. Here, if we take the analogy of GCSEs, A-levels and degree level, what we are trying to aim at is GCSEs. And what we want to do is to try to give able, experienced trust lawyers without significant knowledge of cyber currencies, a basic understanding of what they're dealing with and how they're traded, and how they interface with normal broad investment trust powers. You may ask, why? And we are, of course, dealing with a subject that very few, if any of us, will have learned about in law school. It's developed very fast over the last few years, and indeed is still developing. If I give the example of my own introduction to this subject, it explains exactly why we think that the base level is valuable. And we would welcome your feedback if we've got it wrong. My introduction was a call from an Attorney General of a Commonwealth country with oil and gas wealth and a sovereign wealth fund. It was statutory in its base. It contained an express power to invest in cyber currencies. The Minister of Finance wanted to go into cyber currencies very heavily, and his reasoning was, in times of low interest rates and poor corporate returns, it's the only way in which he thought returns could be delivered. The Prime Minister was much, much more reserved, and that puts it pretty low. Actually, he was dead against it. What he wanted to understand was what was cyber currency, what were the risks involved, and my own reaction was, I'm not an expert in this. The Attorney General's retort was, well, who is? And at that point, which goes back a few years, I was asked to go away, look into it, come back and advise on what we were dealing with. And that's exactly what I did. Now, I want to ask you, the audience, some questions. So down to a poll. My first question is, have you ever experienced cyber currency in practice? It's a yes or no. If you wouldn't mind voting, we just have to wait a few minutes for you to fill in the poll before we go on to the second question. And I'm going to move on now. What's your level of expertise? And there are 3 levels that are going to come back up: beginner, fair working knowledge, expert.
And while you're all answering that, I'll just jump in to say, in case you haven't seen, on the previous poll, we saw 2/3 of you hadn't had any experience in cryptocurrency. So it seems like yeah, there's a third who have, but a lot of people are coming to this new.
Well, I'm looking forward to seeing what the next one is. And Ram, could you tell us, please?
Yes, so I think we've got 79% beginners, so overwhelmingly we're a seminar of beginners on here.
What we're going to do now is this. Ram and Dan are going to give a brief recap on investment powers of trustees, and we expect this is familiar territory. I'm then going to go on to the topic of what is cryptocurrency, and then Stephen is going to take over with the subject of trading cryptocurrency. And finally, we're going to use any remaining time we have, both to deal with questions that we have and also to look at some of the typical situations, if we have time, in which litigation presents. Over to you, Dan and Ram.
Hi, thanks, Lauren. So just starting with what we already know, the basics of investment powers are likely to be familiar to everyone on this call. And in essence, as a matter of statute, they're very broad. So Section 3 of the Trustee Act 2000 provides that the trustees can make any investment that they can make if absolutely entitled to the assets. And the same principle applies in the pension contest in accordance with Section 34 of the Pensions Act 1995. And of course, those powers can be extended or restricted by the provisions of the trust deed. So thinking then how this might apply in relation to an investment in cryptocurrency. Well, clearly the purchase of cryptocurrency is something that trustees could do using assets to which they were absolutely entitled. But the more difficult issue is where the purchase of cryptocurrency is an investment. And there's 2 issues that we're going to just touch on briefly here, and I think Lawrence might deal with them in more depth. The first is that an investment typically involves the purchase of property, but is cryptocurrency property? And the second is that an investment typically involves an asset which generates income, but cryptocurrency does not typically generate income, There's just normally the hope that you'll be able to sell it on for more money than you bought it for. So Daniel, is cryptocurrency property?
It's not quite as straightforward a question to answer as you might think, Ram. I'm sure the last thing anyone is going to want with the final session of the day is an extended philosophical discussion of the concept of property. So I'm just going to mention a couple of quite well-known definitions of property from the case law that we can use to slightly shortcut that. The first is what was said by Lord Justice Fry in the late 19th century case of Colonial Bank and Winnie, where he famously said, you have choses in possession, you have choses in action, and the law knows no tertium quid, there's no third route open. Now, cryptocurrencies clearly aren't choses in possession, there's nothing you can physically reach out and hold. But the decentralized way in which they tend to be administered, and I think Lawrence is going to touch on that in slightly more detail, arguably means they aren't choses in action either. But although they're called currencies, they're not underwritten by an institution such as the central bank, which you can sue. So they don't seem to quite fall neatly within that taxonomy. Another definition is Lord Wilberforce's very famous dictum from Ainsworth, National Provincial Bank in Ainsworth, where he famously said that property has to be definable, it has to be identifiable by third parties, it has to be capable of being transferred to third parties, and it has to have a degree of permanence and stability. And again, without delving too deeply into the underlying mechanics, it's not entirely clear that cryptocurrencies meet all of these requirements. And so while they feel like they probably ought to be property, articulating quite why that is by reference to orthodox principles isn't very easy to do. Now, despite that, the courts have so far been willing to hold that crypto assets are indeed a form of property where they've been required to deal with the question. Quite an early decision was the case of AA against persons unknown, in which Mr. Justice Bryan was prepared to hold that the categories of properties are not closed in the way that Lord Justice Fry seemed to contemplate, and therefore crypto assets could possibly be a sort of additional form of property. Another decision of some relevance is the decision of Mr. Justice Butcher in Ion Science Limited and Persons Unknown, in which he granted a proprietary injunction, among other remedies, in respect of some Bitcoin. There have also been other cases in the UK and indeed in other jurisdictions, and in all of those, the courts have proceeded on the assumption that they probably are property, but also in none of those cases have the courts actually definitively laid down a conceptual basis for saying that they are property. So it seems the courts are adopting a slightly pragmatic approach to this. And it's worth just finally noting on this that HMRC seems to be taking the view that cryptocurrency is an asset capable of being taxed, which possibly also has some relevance to the question. So the answer to your question, Ram, is they probably are property until we're told otherwise. But what about the income requirement? Do they cross that threshold as well?
Well, the question here is whether it matters that cryptocurrency typically doesn't generate income. And in my view, it shouldn't matter. And indeed, this is a question that's been considered by the courts, the question of whether an investment has to provide income. It was considered by Vice-Chancellor Brown Wilkinson, as he then was in Marston, Inspector of Taxes, and Morton. And he concluded that land that did not provide income could nevertheless be an investment. And he gave examples of other non-income producing investments, such as a short-dated stock giving only a capital yield on redemption, or even a work of art. He said there was no reason why those shouldn't fall within the definition of investments. And so if those can fall within the definition of investments despite not producing income, then why not cryptocurrency? Just to polish that off, but I think duties is something that we're going to come to in more detail anyway. Just to bear in mind that this might all be affected by clauses in the trust deed. So for example, as Lawrence mentioned in his case, investments may be expressly authorized, or there may be provisions expressly authorizing more hazardous or speculative investments, which might change the duty of care which the trustees have to adopt. And trustees might also gain protection from exculpatory provisions, which are commonly contained in trust deeds. Although, of course, in the pensions context, Section 33 of the Pensions Act prevents any exclusion of the duty to take reasonable care and skill. That's all. So over to you, Lawrence.
Right. Well, what is cryptocurrency? Well, the first reaction of most competent lawyers, and certainly my first reaction, whether I'm competent or not, is we need to have a careful look at the contractual or other framework in which the currency, if it can be called that, exists. And then we have the tools with which to understand what rights a holder has. What I'm going to try and explain is that the conventional approach is very quickly going to hit a brick wall and is not, in my view, helpful at all. I find this easiest to explain by contrasting cryptocurrency with bonds. If one thinks of a bond, whether it's a corporate bond or a sovereign bond, it is a debt obligation of the issuer, which is secured by an instrument which is tradable, usually on a public market. Just developing this further slightly, take the example of a US T-bill, Treasury bill. The US government will borrow money. It will be repayable at a fixed future date, and it will carry a rate of interest which is specified in the issuing document. As interest rates vary, so will the value of the bond. If interest rates rise, we would expect the value of the bond to fall. It still has the same face value at a future date, at the promise of the US government to pay, but its yield will be less proportionately to what is happening in the market, so we expect the capital value to fall. Another feature to mention is there will be plenty of information available to those coming into the market or thinking to come into the market on the economic outlook and on the issuers themselves, which will let them base their investment decisions. It's perhaps worthwhile going from this. I've used the example of a US T-bill to the subject of credit risk. Let's take another example of a sovereign debt issuer, Argentina. And many of us will have, over the years, been involved in Argentinian bonds, and the credit risk, if I may put it neutrally, is not quite the same as it is with US T-bills, meaning that Argentinian bills are discounted. Well, let's move from there to Bitcoin so I can develop the contrast. The basic story is famous, and I'm not going to run through it in detail. A specific number of units were set up by a private person or entity, possibly fictitious. Those units can be and have been subdivided. What obligation does the issuer assume? The answer is absolutely none. The units can be sold, they are traded, but the obligation which is assumed is an obligation between counterparties. Are there obligations between the counterparties? The answer is yes, but the practical problems are really very numerous. They are often anonymous counterparties. For example, if you're trying to trade a ton of hashish or machine guns for Bitcoin, you're not likely to be capable of finding out who your counterparty is. Equally, it's not just the absence of information on the counterparty. Very often, the terms of the trade, whether it's even buying a Bitcoin for money, are often very sketchy, and they do sometimes come through the medium of exchanges. Now, the analogy, which not everyone likes, but I do, is if you pick up a glass and you think of it filled with champagne, you know what it's worth. It's the value of a glass of champagne. If you take that same glass and you say, what am I selling with Bitcoin? you're selling the contents of the glass, and what is in it? The answer is absolutely nothing. Does it have value? Yes, it has value, because what it's worth is what someone will pay you for what is within the wrapper of the glass, despite the fact that there is nothing tangible in it. It leads really to the question which Ram and Dan were trying to develop a few moments ago. Is it property? Well, it's a wonderful legal philosophical debate which consumes the academically minded and will do for years to come. To my mind, it's a debate which is completely arid, and it's the wrong question to be asking. The question which I think is material and reflects the approach of the courts, though not quite put in these terms, is, can cryptocurrency be an asset? An asset, unlike the debates about what is property and what isn't, comes to this. An asset is something which is capable of being seized by creditors in order to satisfy debts. Put in those terms, obviously, cryptocurrency is an asset, and it is something which, if you can get your hands on it, is capable of being seized to satisfy debts. The difficulties which there are not, in my view, theoretical, they are practical. They are the difficulties of obtaining jurisdiction against the counterparty to a transaction, usually in personam jurisdiction, and enforcing any judgment in the light of the practical difficulties of a lack of information about where the assets are, being even able to find and tie down the cryptocurrency. With a compliant debtor, there's no problem. With one who is not compliant, the problem's are legion. I want to move on just from this, accepting, as have Ram and I think Dan, that we can see in cryptocurrency freezing orders, freezing it. We can find disclosure of assets orders. We can even find proprietary freezing orders. They can be the subject of a constructive trust or an express trust, but that, to me, is background. The question which we then have to go on to is something which is practical about the nature of cryptocurrency. If one thinks of the way in which it's traded, and Stephen will be giving you more on the method, what I just want to concentrate on is this: information, regulation, drivers of price. Information on what the sort of features that drive price rises or falls is not available. What actually makes price go up and down? And the answer is this. People are in this market, they try and make money. And when it comes to who the people are, there's another material feature to mention. It's often said that 80% of Bitcoin, and sometimes it's said 90%, is in the control of 1% of those who participate in the market. This leads to extreme volatility. And just to give you some figures, Bitcoin, of course, started less than 20 years ago with a trading price of a few dollars a unit. By November the 11th, 2021, when it reached its peak of just over $51,000 per Bitcoin. The rise was astronomical, and what had driven it up. By December the 6th, though, the price had fallen to 37,500 per unit. By January 21st of this year, so just over a month later and under a week ago, it was down to 30,000 a unit. On Monday, there was a big fall, and we saw the prices down into the 25,000s. Today, when I last looked, although this may have changed, we'd seen a 15% rise in the value of a unit. The lessons, to me, are what we're dealing with. If one's going to enter the market, it's much more extreme even than a volatile equity. What drives it? Who knows? It's not like the trader of equities who goes to bed with his computer on the bedside table. This has to be watched 24 hours a day on a minute-by-minute basis. And the feature which the Minister of Finance in my original case spoke of it's the only way of getting returns, what one actually sees is big professional players sitting there with resources, watching what's happening minute by minute. And we have the emergence as well of market makers, as well as trading exchanges, which further complicates the position. Is this anything other than pure speculation? Well, I haven't got time this afternoon to speculate, but perhaps if we have time at the end, we can have some amusing stories about it. Over to Stephen.
Thank you, Lawrence. What we're going to do is depart slightly from the programme, and we're going to explore trading cybercurrency in the context of a pretend trustee meeting, in which Lawrence is going to be the chairman of the trustees, and I'm going to be the professional advisor advising the trustees in relation to the questions that they have as to whether or not they should, in practice, invest in some form of crypto assets. We've heard from Dan and Ram that, in theory, that's something that's within their power to do, but now they want to explore whether or not they should actually be going ahead and doing it. Here we are in our meeting. The trustees are eager to invest, but they're concerned, as any prudent trustee could be. Lawrence, what's your first question?
Can I get legal advice?
Sorry?
Can I take legal advice?
That's not your first question, so you've already failed on that. Your first question is, why should you be considering acquiring digital assets at all? And the answer to that, of course, is that traditional assets are producing poor returns, and they have been doing for some time. And that can be a serious concern to trustees, particularly where they're expected to maximize the assets of the trust. But by contrast, crypto assets have been showing remarkable returns, but also in cases, as we've just heard from Lawrence, displaying very high volatility. So for instance, we've seen reports in the paper that Bitcoin is going to quadruple in value over the next 4 years. But we've also seen that individuals such as Elon Musk can significantly influence its value. When he announced that he wasn't going to allow Tesla cars to be acquired using Bitcoin, the value of Bitcoin dropped by 17% in one day. Then there are NFTs. Again, in my day, show my age, that used to be the National Film Theatre, but now it's non-fungible tokens, which are really digital certificates of authenticity, and those are trading at astonishing prices. You probably saw in the press that the NFT every day, the first 5,000 days, by Beeple, sold at Christie's auction for $69.3 million. And that was from a reserve price of just $100. And an earlier Beeple was sold in February 2021 for $6.9 million. The lucky chap that had acquired it had done so in October 2020 for just $70,000. So it's 100 times increase in 4 months. And you may have seen in the paper today that John Lennon's son is now going to be selling NFTs granting rights over his father's memorabilia. Now, there is a concern, of course, that you should be aware of as trustees, that this may just be a bubble that pops. A former Christie's auctioneer said it made no sense, as buying something that isn't there is just strange. But it's unsurprising that someone used to dealing with physical objects should take that view. At the other end of the extreme, real people are buying what's called real estate in virtual worlds. It would be something of a failure of the imagination to think that just because something only exists online, it has no real value. In a sense, we've created a new dimension and people are moving into it. So I think it's very unlikely that the bubble is going to burst. And as trustees, therefore, you have to be alive to the possibilities of investing in this form of assets.
What could go wrong?
Can cyber assets be hacked?
Absolutely, they can. They all exist in the ether and depend on cryptocurrency, and they can therefore be hacked. For example, you may have seen that the MT Gox hack back in 2014. They had something like 850,000 Bitcoins stolen, which at the time was something like 6% of all the Bitcoin in circulation, with a value of around $837 million. So it's probably the case after the event that these were stolen from the hot wallet over a period of 4 years. As after the event, that's what they think must have happened. GOT went into liquidation in 2015, and of course, the investors lost an awful lot of money. Now, you might say, really, in one sense, that's no different from investing in movable physical assets, which can be stolen. It was just, on this occasion, stolen in a different way.
Is there any way we can protect against the risk of hacking?
There is. The exchanges which have popped up and which are probably the place where responsible trustees should be thinking about making their acquisitions are developing new levels of security all the time. There'll be advisors who can assist you with identifying the safest platforms, and some of those platforms are insurance backed. So we'll come on to some conclusions, but there are things you can do to protect against hacking.
And what about scams? I mean, how high is the risk, for example, of your counterparty being fraudulent and scamming you?
Well, the Financial Conduct Authority, among others, has offered some guidance on this, and what they've done is they've plainly had a look at the kind of things which are going on. And actually, the scams really are not that much different from scams that go on not in the virtual world, in the real world. They've given the appearance of respectability, often with a UK branch at a prestigious address, whereas in fact they're overseas and they're either selling non-existent crypto assets, or they're likely to close your account without warning or ask for more money before making a transfer. And as one can see, that's really not that different from when people invest in non-existent property developments in other countries or similar scams. So inevitably, these things are going on, and I want us to just be alive to that and trade responsibly through the most respectable of the exchanges, probably.
And what about money laundering? Could we get involved in that?
Well, when you say could you get involved in it, you mean could you get caught up in it?
Is there a risk we could get involved in?
Money laundering obviously is very profitable, but I wouldn't advise you to get involved in it. From 2020, the UK-based crypto asset businesses have had to comply with the money laundering regulations and register with the Financial Conduct Authority. Obviously, that reduces the risk, but there's still going to be a higher risk than one might associate with the more traditional financial instruments.
Is there anything else we need to bear in mind?
Well, there's the question of volatility, which of course we've already heard about. I saw there was a recent case where someone sought an injunction and they had to give the usual cross undertaking in damages. And the court rejected a submission that it was supported by the Bitcoin balance sheet of the applicant. because of the volatility of Bitcoin. Now, that's not really directly an issue for trustees, but it's interesting that that volatility can impact in that way. And I anticipate that that'd also be a problem for actuaries, for instance, balancing the or giving a valuation for a pension scheme, because the volatility is just huge. Whether Bitcoins are a bubble is largely unknown, but as I said before, I suspect that it's not. The virtual world is very real to some people, and once a market's developed to critical mass, it tends to keep going.
If something does go wrong, how can we seek redress? And if I can add to that, a question which has popped up on our Q&A, and it's, what do we think about the jurisdictional analysis on crypto? Because if one actually goes back to suing persons unknown, what we're seeking to do is we're seeking personal jurisdiction of some kind to deal with property within the jurisdiction as the jurisdictional peg difficult. And I hope that you're going to say something about Norwich as a useful method in seeking redress.
Well, in practice, I suspect one just jumps right to the end of this sort of problem and says, well, where are these people going to be? And how susceptible really are they going to be to English worldwide freezing orders? And the answer probably is that they won't really care at all. They'll be buried away somewhere where they're very hard to find. I'm going to mention Norwich because Norwich Pharmacal orders, bankers' trust orders, those kind of things can bite against institutions or companies operating in this country. And it is therefore possible to obtain effectively sort of disclosure through third parties who are going to have concerns about their reputations. But I think it's probably very early days as yet to have any confidence that there is rapid and effective redress in these circumstances. And even in the real world of real assets, it's very hard, as we know these days, quite often to track down assets that have been fraudulently hidden away. I suspect even more so in relation to something that exists out in the ether. And therefore, again, from a trustee's perspective, really it's about making sure that you don't get into those circumstances in the first place by making sure any investments that you do make in crypto assets are through proper exchanges or are with known and reliable entities.
So would it come to this? If you want to buy a Tesla with Bitcoin, that's fine. But if you want to buy it to see its appreciation in value, what's the outcome? Should you do it?
Well, I'm not sure if you all turned up in your Teslas for the next trustee meeting, that the beneficiaries would think their money was being well spent. But I think that's probably right, that at the moment, at this point in time, you probably should wait and see what happens with the crypto world, with the crypto assets, or only make modest investments in the safer crypto assets. A big gamble at this stage could pay off for an investor, but that's probably outside the scope of what a trustee acting responsibly should do. And as you said earlier, Lawrence, if you are trading cryptocurrency with the intention of making a turn on that, then you do need some mechanism in place for deciding when to trade in order to take advantage of the market conditions. And that's not necessarily something that's going to be available to a small trust. It might be to a large pension scheme. I don't know if you've got any more questions for me at this stage, or whether we should just move on to the last item on the agenda, since we're clearly running slightly over time, which is our sort of tentative conclusions. And I've slightly spoiled that by mentioning my own slightly tentative conclusions, which is to say that I think there will be a class of assets, crypto assets, which becomes more sophisticated, more highly regulated, better understood, And probably that day is not that far off. But at the moment, it is still relatively uncharted. And although there's probably a group of core crypto assets that are understood and recognizable, it would be a risk for trustees to make any significant investment in that at this stage, both because of their volatility or because of the prospect of the bubble in some of these things bursting. Well, I think my view is that it won't burst. It will actually probably go from strength to strength.
My question is, we've been talking about Bitcoin, which of course has a huge value, I say value, price, and we've seen phenomenal rises. We see other much more modestly priced units of cryptocurrency, some of which were even invented as a joke. Would one be safer in going for currency which was traded in cents rather than tens of thousands of dollars?
Well, I mean, you're right. There are apparently around 1,000 different cryptocurrencies these days, and it sort of begs the question, really, why a lot of those are proprietary and there for specific purposes. But why would you invest in many of those when really half of them are pegged to dollars or to some other algorithm, or to an algorithm? Why not, for the time being, invest in real fiat currency backed by an institution?
I was expecting someone to ask what the substance of the advice that I gave to the Commonwealth government was, but no one has been bold enough. I'm not a cynic, really.
I'll ask it. What was the substance of the advice you gave?
Are you trying to lose your money? In substance, could you expect a governmental authority to put in the time, effort, and at sufficient speed to decide what to do in rapidly moving markets? I broadly said, my advice was, no, it's speculation. It's probably safer if you can get a tip on who is going to win the 3 o'clock at Haydock at good odds to put your money on that than it is on this. But that was my view, and it hasn't changed much. If one goes back to how is the market changing, we are inevitably seeing the increased involvement in regulation. In the UK, we're seeing small steps to it. In the United States, we're seeing small steps to it. And if one adds anti-money laundering, the fundamental is, starts with KYC, know your client, know your counterparty even, who are you dealing with and for what? It contravenes every principle of sound common sense and business-like behaviour. So I'm not an enthusiast, apart from the fact there is real work for all of us in it, and I suspect that there will be more in the future. And I think if we can just use our last moment or two to think of the situations that many of us will have experienced in practice. Number one, redress against trustees who've lost the shirt of the trust. Stephen or Ram or Ram?
Redress against trustees. So I think the reality is that options for beneficiaries are likely to be limited, and the main reason for that is the provisions of the trustee. So in the private client context, at least, it's very common to have exculpatory provisions, and unless you can show bad faith or fraud on the part of the trustees, that's likely to very much limit your options. The pensions context, of course, might be different.
Scams, I don't think we need to say anything about. That's trustees trying to pursue them, but that's a subject which we'll deal with in a different seminar. But the final one, which I'm certainly starting to experience, is the possible responsibility of investment advisors to the trust who have advised exposure. And at that point, I think we will leave it.
Well, thank you very much, Lawrence, Stephen, Dan, and Ram, for that fascinating discussion. I can see I'm going to have to think very carefully about any crypto-related investment decisions. Sadly, that brings us to the close of today's events.